Can I get the water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all now. I ain't gonna tell you no lie.
Yes, you may. We're gonna take a break soon. Hang in.
Well, welcome back, everyone, Inside the Law. I'm your host, Philip Holloway. Those of you who have been with us before, you might remember Hi Guy, who we just saw. And those of you who are new to the channel, well, that's Hi Guy. And how is he relevant? Well, he's relevant to another Fani Willis fiasco that is perhaps a little less known that's going on right now in the Fulton County Superior Court. It's the massive racketeering trial of Atlanta's own Young Thug, the recording artist and rapper known as Young Thug, along with a bunch of other people have been accused of racketeering. Again, you know, Fani Willis loves these giant cases, and she likes to try to create a big spectacle by making the case just as big as it possibly can be. And quite frankly, courts have a very hard time fully digesting cases that are that massive. But she's done it again. And by way of recap, in case you don't remember, this case started years ago, and jury selection itself took over a year. Okay. And now it's been speculated that the case may go into 2027. So this is what I call the Young Thug Fani Willis fiasco in Fulton County. You probably will remember, let's bring back the one, the only Rachel Kaufman, who is our resident Young Thug #1 fan, and of course has represented people associated with this case. Rachel, what's going on this afternoon?
I'm eating some peanut M&Ms. I'm enjoying this beautiful day in Atlanta, and I'm excited to chat with you about what's been going on this week in Fulton County.
Well, it is a beautiful day in Atlanta, and I've got my Atlanta Braves jersey on because I'm going to the Braves game tonight when we finish, and I'm very excited about the great weather. I hope it's good weather where everybody else is, but I'm sure somebody's got something. Maybe it's raining somewhere, but it's not here, so we're enjoying it. Also, we've got another very special guest that I want to introduce you to, but before we do that, I've got a little bit of video to play because something happened. I mean, this court is truly turning into a kangaroo court, in my opinion. I mean, it's just an absolute dumpster fire because, again, this is a case that can't be fully digested by the courts. Everybody's getting frustrated. The lawyers are getting frustrated. The judge, as you'll see, is getting really frustrated. And by the way, the judge early on in the case, I mean, he was holding people in contempt hand over fist. I'm talking about lawyers. I'm talking about potential jurors. I mean, it was like all you had to do was, it seems like, look at him wrong, and he was ready to hold you in contempt. But then something happened this week, and it's quite remarkable. So have a look at this.
Okay, so I'm going to ask the state their issue on this. Are you cutting this out? Did you have discussions with Mr. Sharp, madam?
We did have discussions.
When?
Well, this morning.
That's too late. The evidence is excluded. The evidence is excluded. I'm going to exclude because I told you that this was going to happen. No. We're excluding that, and I'm going to exclude the PowerPoint that you all submitted. Well, you're not going to wholesale introduce it.
We had no intention. Your Honor,
all right.
Let's be real clear. We did not intend to introduce this PowerPoint today. I have personally reached out via telephone and called at least 2 members of the defense team and asked them to call me back. And I would like
but you all should not be identifying this stuff the moment of trial while the jury's sitting in a box. This is the last. I am not going to tolerate this any further. If you don't get together with your colleagues and flag issues and resolve them promptly, and if I have to take them up, remember, I can exclude them. We'll work the weekends, or we'll do a combination of both. So this time, I'm going to exclude those 2 sections.
Your Honor, Mr. Atkins, he confronted this witness with those sections. I last week let them know that we were introducing that.
If the exhibit's not ready and you haven't made, and you, no, well, Mr. Sharp's got objections to it.
Judge, information
No.
at midnight and then comes in and says,
Well, then you all should have gotten your stuff together before then. Some of our juries, please. Some of our juries. Have a seat, madam. Have a seat. You better exclude that, and next time, make sure you're prepared. Make sure you're prepared next time. I'm not going to do this anymore. I'm just not. We are starting right now. It's 1:20. So
we have talked to them. We have said we don't agree.
then file a motion and get it before me, and we'll take it up. Both of you all have equally responsibility to do that.
Information they are seeking.
Oh, it's going to be inadmissible right now.
I'm saying, Judge, that you said to file a motion. There's nothing.
I'm not going to have any more discussion about this, madam. I'm not.
Talked to them this morning
I don't.
about that.
Well, you know what?
And I attempted to try to talk to them earlier this week.
Well, then that's why we have to.
Your Honor, so the court punishes the state because the defense.
I'm not punishing anybody, but but prior preparation prevents poor performance.
Be prepared, Judge. That's why I sent them what I sent them last week, a whole week and a half ago, 2 weeks. Your
I'm
Honor.
not. Well,
And I have asked. I have said I would like to discuss.
our jury's coming in, madam. Our jury's coming in. Have a seat.
Before I bring my guests back in, it occurs to me that maybe those two should just go out in the parking lot and settle their differences the old-fashioned way, because that is no way for a lawyer to behave in court. And honestly, it's no way for a judge, in my opinion, to behave in court either. The judge should not have let it get that far. But this is a fiasco. I mean, this is an embarrassment. This is on par with Fani Willis busting in like a wildcat with her tail on fire, insisting to testify when she ran in and just started calling everybody liars and throwing papers around. This is absolute ridiculousness. And if I were to do something like that, I would expect to be in jail, held in jail for contempt of court. Whether you agree with the judge's ruling or not, you've got to respect that ruling, and you can't yell at him. And the judge can't be yelling at the attorneys either, by the way. That's just not the way courts are supposed to run. Here at Inside the Law, our mission is to bring you the good, the bad, and even the ugly that sometimes rears its head in the criminal justice system in America. And that, my friends, is some real ugliness. Now, I mean, a lot of people think it's funny, and in a certain way, it is. We can all get a laugh out of it, but it's really, really bad. And this is just not a good look. This is not the kind of thing. I talked the other day about we want historians to look back on these big trials and to be able to say with confidence that justice, whatever that may be, was reached in a case, whether it's a conviction, whether it's an acquittal or whatever. But this makes a mockery, not only of this trial, but it makes a mockery of the entire justice system. All right. So now that I'm got that off my chest, I want to bring back to the stage. Let's bring back Rachel Kaufman and also our good friend, attorney Doug Weinstein. There he is. Yeah. Hey, Doug is traveling to parts unknown. We won't let you know where he is, but he's somewhere where it's very sunny. I see his windows are down and his sunroof is open. So hopefully he's going somewhere very nice. But Doug represents one of the defendants in this case, and he's going to share with us some very, very valuable insight. He's not going to be able to talk really about the specifics of the case as it pertains to his client. We're not going to ask him to say anything that's inappropriate, but he's there. I mean, he is in the room and he sees this crap. And by the way, he's been in the room for a long time now. I think he's got another team of lawyers, so he's not stuck there maybe every minute of every day. But nevertheless, he's been there from the beginning, and I think he's got a lot that he could tell us about. Welcome, Doug. How are you?
I'm doing great. Thank you for having me on.
Oh, listen, thank you for taking the
sorry
time
about
out of
the
your trip.
Yeah, sorry about the circumstances of being pulled over here on the side of my car, but I'm happy to join y'all.
Yeah. All right. So let me start out by asking you, what in the hell was that we just saw?
Well, let me say this. So we have been in that courtroom in trial. Let's forget all the pretrial stuff since January the 5th, 2023. So we've been in there about 16 months. with very few breaks. And I think everybody involved, the defendants, the state, the defense attorneys, I think we're all pretty exhausted and all pretty tired. And it's actually surprising how well some of us do manage to get along. And I think what you just saw there was frustration, exhaustion, tempers overflowing. I can tell you, if that would have been Suri Chata Jimenez that yelled at the judge like that, I think Suri would still be sitting behind bars.
All right. Well, let me pause you for a second, because I want to. Look, I need a whiteboard to keep up with all the twists and turns of all the crap that's going on in Fulton Superior Court right now, certainly with this case. But take us back to the beginning. I remember lots of instances when this case first kicked off with even like with jury selection, the judge was really, really quick to hold people in contempt, even attorneys and jurors, potential jurors. What was the deal with all that? And can you give us any examples that you remember?
Well, I think as far as holding attorneys in contempt, there were a few instances where some attorneys were late, and he had the attorneys buy lunch for everybody or all the other defense counsel. And his reasoning for that was, well, they were wasting our time, and therefore they should be punished in some way. I think that only happened a few times. With the jurors, most of the time that was them not showing up for court or not coming back again, and the judge trying to set an example. I remember one in particular who ran off to the DR, the Dominican Republic, and I believe that juror ended up having to write maybe that was a 30-page paper, APA style, with 20 citations to primary and secondary sources. I'm sure that poor juror had to look up and figure out what that even was. But that was kind of early on, and I think the judge was just trying to set a tone of having people come on time. Now I think everybody is just, we're all just tired.
All right. Well, look, I've been trying cases and practicing law for 27 or 8 years now, and I've never seen a judge order a juror to write, an annotated, essay or a, some type of a dissertation or whatever the hell you call it. But it was a very big project that he ordered this potential juror to do. And honestly, it seemed to me like he was a little, in my opinion, the judge was just a little too quick to throw people in, or hold them in contempt. I don't know if he ever actually jailed somebody, did he?
He held some people back behind the courtroom, but nobody ever went over to Rice Street.
Okay, so he put him back in the holding cell.
Hold on.
Yeah, he was pretty patient with most people. It was only a few of the jurors that were really egregiously not showing up that he did that to.
What Adrian did is so much more egregious than not showing up. I would pay her to not show up. I'm going to say things that Doug can't see. Doug, I'll say it. Like, that's how Adrian acts, no matter the circumstance. She acts like that, whether she's exhausted or not. She can actually go the distance, which is why Fani put her on the case. She's like a gigantic workhorse. I've said this before. She can take hits. She doesn't mind being admonished. She just kind of says, oops, I didn't realize, or talks around things, or just talks off the ears of the donkey. I love donkeys, but touch their ears, Adrian. She would, hurt a donkey. Everything she does, you just hear the nastiness in her tone of voice, and just that it's gone unchecked for decades.
Well, I think, in this case, perhaps there's been a bit of negative reinforcement, just in the sense that when she loses any of her motions, whatever it is, if she loses, she will continue to argue. And more than a few times, the judge has changed his mind. So I imagine the state has learned that if they keep arguing, the judge may turn. Now, since I filed the motion at the end of March to try to move this thing along, back when they had 400 witnesses on their list, cut down from 700, since that motion has been filed, I think the judge has been much less patient with any party arguing his rulings. I don't know what happened on Wednesday morning, where where she continued to do that. And
all right, well, I've got something that I think is a good example of another example of her continuing to argue. Check this out.
What's the basis for its admission? Why do I need to hear it? I can read it and say, I can read it and tell you it probably doesn't have anything to do with what we're covering.
Well, Your Honor, the court and counsel are aware our rules of evidence favor inclusion, and this is not inadmissible. There's nothing inadmissible about these portions that were brought to our attention, or else we would have flagged them. We've actually agreed to take out things that were not permissible.
It's not relevant. It's not relevant. How is somebody about this conversation relevant for anything? What does the carjacking with federal agent have anything to do with it?
As the court recalls, when we last time excluded a chunk of information and attempted to play portions that became relevant when a witness did not understand, we were denied the opportunity to do so. That is why we are asking that the court not whole grant chunks of information be excluded without hearing the chunks of information and allowing the state the opportunity to point out the portions where we disagree.
We're not going through what we went through this morning, Ms. Love. I'm sorry. I am sorry. We're not doing that. I excluded that because look, I made my ruling on that particular issue. So I'm not going back and talking about that.
Then don't.
I have a question for the court, because I think the state.
I already ruled that we were going to exclude that particular portion. I ruled on it because we had argument on it. So
So Your Honor, the state just wants.
All right, so if I'm not mistaken, here what we have there, and by the way, thank you so much, Chuck, for the super chat. Much appreciated. If I understand what I just saw, the judge had made a ruling, something was not relevant, it wasn't going to come in, but she kept pressing the issue. And tell me, Doug, who was that other attorney that stepped up to the lectern there towards the end of that I guess wanted to also be heard?
That's Simone Hilton, and I think she's a very good attorney. I think she's a very fair prosecutor. We can work with her.
Yeah. But it's nevertheless a prosecutor wanting to still push the issue and get the judge to revisit something.
I was about to say, we all have bosses.
Yeah.
Well, okay. So are you saying that Fani Willis, is micromanaging this case and telling them to keep pushing against the judge?
No, Adrian's micromanaging.
I have absolutely zero insight into that.
No, but Adrian is definitely the captain of their ship, which is why they end up in these arguments. When I saw you, Doug, last week in the courtroom, it was because I was there because one of my clients is not on the reduced witness list. So they went from 400 to 200. So she's under subpoena. They said there's the sequestration in place. And now that she's not on the witness list, we went in there. She's Stillwell's fiance. And Adrian, if it was just Simone, I think she would have just been like, fine. But Adrian just wants to fight on everything.
Well, that's why this case is going to take till 2027. It's like the judge has already ruled, and apparently he had done so earlier in the morning, but they just keep on and on and on with it. It's like my kids, when you tell them no, then they just keep on and on and on, and they won't take no for an answer.
No, but he baits the judge baits her.
I set that 2027 number out in my motion, and that was just based on pure math with how many witnesses we've gone through and how many were left on the list. I think now the state is down to about another 150 witnesses. So my current estimate is summer of 2025, which would be wonderful. It's better than 2027. I mean, none of this is good. I begged the court. I gave plenty of case law to put a time limit on the state. Courts have done it all over the country, put time limits on the state. Because the issue is just like what this federal judge up in Kentucky said years ago, and it's been adopted all over the country. At some point in every lawyer's life, when they were a young lawyer, they lost a case because they left something out that maybe they should have put on. Yep. So this judge says, look, so now lawyers want to pile everything on. And in civil practice, you've got money and fees that put somewhat of a limit on it. But when you're in criminal practice and the state is getting paid, no matter what they're doing, they want to put on everything. And so that's what you've got. You've got the state putting on witnesses without limit. And I'll continue to object when there's cumulative material presented. And, my client is sitting in jail while this is going on, and it's just not right.
Remember,
it's just not right.
All right, Doug, you've got a right to remain silent. So remember that. But my question to you is, have you yourself have you sparred with the judge any at all with your objections or with any motions? Has anything like this ever happened with you?
I believe the judge has always been courteous to me when I've dealt with him. I think I have a pretty good relationship with him. There have been times we got into it, like before trial began, or before we brought in a jury. I think we already got the jury. We got the panel set, and it was a matter of seating arrangements. And he and I got into it a little bit when I insisted that my client have line of sight to the witness. Because when a witness got on the stand and testified about something about my client, I wanted him to have that witness to have to look my client in the eye when he said it, or at least to avert his eyes, because he has a right to.
Your client has
an absolute right to confront the witness.
Defense, and
right,
participating in your defense means looking at the witness, judging their mannerisms and the way that they testify, because you can, the clients may see something that you miss. So it's very important for them to. And in the beginning, I think y'all are still having to wear masks and shit all the time, and so you really got to be able to see the mouth moving, right?
Yes. So the judge lost patience with me for insisting upon that without presenting a solution, because my answer was, I'm not the one that decided to indict 28 people.
It's not your job.
Try to cram them all into a courtroom.
It's his job to create the fair courtroom. It's his job.
Well, and it's the state for putting the judge in this position too.
True. So, well, I mean, Fani could have created an indictment that was less broad, that didn't have, 30 or something defendants, what you started with.
Many of us have asked for severance. This anyway, I don't want to get into that. She could have created a much unwieldy
charge. Yeah, she did that. It's just like the Trump RICO case. I mean, the bigger it is, courts just can't fully digest it. Look, I want to move on. I know your time is limited. There was another thing that happened this week. Now, let me set this up a little bit for those of you who are perhaps laypersons or lawyers who may not remember from law school. There is a type of a hearing. It's, well, depending on where you live. In Atlanta, I call it a Daubert hearing. It might be called a Daubert hearing in some places. Daubert, and that kind of hearing is used to determine when expert or certain scientific evidence can be presented to a jury. In other words, it's got the evidence itself has to be scientifically reliable enough so that it's basically not junk science. It's appropriate for a jury to consider in deciding a very important issue like whether somebody's guilty of a crime. And so the judge has to have this hearing, and it's always done outside the presence of the jury, because we don't know yet if the jury is going to be allowed to even consider it. So it's always done outside the presence of a jury. But this week, and I've never seen this before in my life, but this week we had a Daubert hearing that occurred in the presence of this jury. And before I get you to talk about it, Doug, I want to show a little bit more video. I promise, guys, I'm not going to just do this the whole show, but you got to see this to understand what's going on. All right.
Now, you said that you spent a lot of time getting to know your beat. Was it your goal when you were getting to know your beat to go out and make arrests? Was that your main priority?
No.
What was your priority when you went out to know your beat?
Really, the priority was to stay away from 911 calls. I mean, just, if we're being honest. So if that included, just doing directed patrols, doing drop-ins, which is my businesses on my beat. I would go into the stores, talk to the store owners. The old guys sitting on the side of the building drinking, they give you a lot of information. So my priority wasn't to lock people up. I wasn't trying to be on I-20 doing accident reports.
All right. How long did you stay in patrol at Zone 4?
A little over a year.
Is that the normal time that a new officer stays at that level?
No,
What's usually the time? Is it more or less?
probably more.
All right. So, did you get out generally earlier than normal?
I did.
All right. Now, what happened that caused you to leave patrol in zone 4 earlier than normal?
I guess my supervisors figured me out and they put me on the 15, which is the field investigative team. It's plain clothes. You do proactive work. So,
When you say figured you out, what do you mean?
they saw I wasn't answering 911 calls, so they used me in a better capacity.
When you say proactive work, please explain what you're talking about to the jury. What do you mean?
For me, just getting out your car, walking around, talking to groups of guys. Again, if it led to an arrest, it was an arrest. If it was a traffic stop, that led to an arrest or seizure of guns, drugs, that's just what it was. It's just being just proactive.
All right. So, Doug, I'm going to ask you to tell us what we just saw, but it's my understanding that was a witness. You couldn't see the witness, but that was the proposed gang expert that I understand was also maybe a fact witness as well. And of course, experts are allowed to give opinions, and fact witnesses can only address facts. But this was the subject matter, I understand, of this Daubert hearing. What's going on, Doug?
Right. So many issues to unpack here. So yes, this is one of, I believe, 5 gang experts that the state plans or has presented. She was not identified as a potential expert until this week, which is why we're having the Daubert hearing now instead of prior to the beginning of trial, as we did with many of the others. So, I have been practicing since '98. I have been a part of scores, I don't know how many, of Daubert hearings in federal court all over the country. Northern District of California, Central District, Southern District, Eastern District of Texas, Delaware, Eastern District of Virginia. I mean, all over the place. I've never seen a Daubert hearing done in the presence of a jury. So I requested the judge to conduct this outside the presence of the jury. He declined. So
why? Why would he decline?
I don't know. I mean, I don't want to get into his head. I'm not really sure.
All right.
But
maybe he just
brought the jury out.
Error.
I can speculate
I can't
later.
say.
I'll speculate in a minute.
You can.
Just wait. Yeah.
We'll let Rachel.
So that's
that
that's the first issue is the jury sits there and watches that. And you notice that when the state is questioning this witness, the state asks the witness, please tell the jury. Well, it's not the jury actually making that Daubert decision on whether they're an expert. That's up to the judge. And so you see some of the issues with that. And then on top of that, here's another example of one of their dual role witnesses, someone who's a fact witness, and they also want to present them as an expert witness. And there's all kinds of case law about why this is not best practices, but the state doesn't care about best practices.
They do not.
So they think, they put forward to the court that a limiting instruction will solve all of the issues, and it doesn't. And so the judge did give a limiting instruction, but it's hard to follow that if you're a juror, wouldn't you say, Rachel?
Yeah, the instruction, I was actually thinking also because Adrian speaks so slowly, as does this Gaither, whatever she is, gang, I call him her schmexpert, gang schmexpert. They talk so slow that, and the judge is giving this instruction. There's just no way if you have any attention deficit issues, you're paying attention. Like, they lost me so long ago. The instruction's confusing, would be confusing to an attorney. And really, what went on talking about her growing up in Chicago and her parents saying, stay away from gangs, and talking about what gang activity was like in the 80s and 90s. Completely irrelevant.
How is that relevant?
That's 2027. That's when you say 2027. It's like, well, you know what? If she's going to be allowed to talk about that stuff, that's completely irrelevant.
Did I hear that witness say that she was essentially electing not to answer 911 calls, and so they promoted her because of that?
That's what you just heard. You heard somebody say, well, I wasn't doing my job as a patrol officer, because she had said a little bit earlier, my job as a patrol officer was to respond to 911 calls. She wasn't doing her job, so they don't fire her. They're like, we'll put you in the gang unit, let you go around in plain clothes and be proactive and like arrest people. That's like, again,
that was in Chicago or was that here?
But I'm like, that cannot be what the founders intended. That is not, I do not want my tax dollars going to her doing that, to her going out and doing those things. It's offensive. And it's offensive that you didn't want to respond to 911 calls. So they promoted you. You got more money. And now got like officer of the year, investigator of the year. That's scary to me.
Yeah. And here she's still on direct, and she's going to continue on direct this coming week. So we haven't had the opportunity to cross her yet. But what happened is with this dual role witness is she testified for a bit as an expert. And then the state says, okay, her expert part is over. And now she's a fact witness. And the jury is supposed to figure out, okay, now if we can even remember the instruction the judge gave, now we're supposed to give different consideration to this testimony than we did to the testimony previously. But of course, basically you've got all this bolstering because they've heard her as an expert. So now when she's giving her fact testimony, the juries are humans. By human nature, they're going to hear what she has to say as a fact witness and say, oh, well, she's an expert and we should give extra weight to this fact testimony, which is one of the many reasons that most courts have said you really should try to avoid these dual role witnesses if at all possible. And here it's more than if at all possible.
Yeah. It makes me mad because what's best practice is best practice for justice, not for them winning. And so that becomes a problem for them when that's all they're concerned with. I want to ask her if she's, I'm not a fisherman, but I feel like she likes to cast net fish. That's what she does that's what she's a gang expert to the extent that she's an expert in persecuting them.
Yeah. Well, if you watched any of her testimony, she once again gave testimony about the album that was the collaboration between Future and Young Thug, which is this, the album cover has a snake intertwined with a bird skull. And she's, if all yours is a hammer, everything you see is a nail. So everything to these gang experts, everything is gang activity, is gang related.
Yeah.
Doug, you're wearing red, so you're a blood.
I know, Doug, you're traveling and you've got limited time with us, and we've kept you here for 30 minutes now. But before you go, and by the way, there's now almost 900 people in here watching live. When we first started, there was obviously less. It takes a few minutes sometimes for people to see the notification and to come in. So I want to replay something, and then I want you to tell me more background about what this is.
Man, can I get the water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all now. I ain't gonna tell you no lie.
Yes, you may. We're gonna take a break soon. Hang in.
All right. So we played that at the beginning, and I've played it before. It's one of my favorites, as people know. But since you're here, I need to know who the hell was that, and what is the context behind what we just saw?
Well, that's Mr. Bean. He's one of the state's many star witnesses that have gone south on him on the stand. And actually, when I was in court, and I sit at the very front, I think I can hear pretty clearly. I think what my brain probably did was assumed what he said. I thought he said that he was so hot that he was about to go to sleep. So when I saw everything flying around saying, he said hi. At the end of the day, I went back with the court reporter and looked at it to make sure he really did say hi. Mm-hmm. He didn't want to be there. He didn't want to testify the way the state wanted him to testify.
Well,
if I remember right, let me just say, if I remember right, he had been on and off the stand for about 3 weeks, maybe at this point. Now, I may be remembering that wrong because this all begins to run together without my notes in front of me. But these witnesses, these star witnesses they're bringing on, they're just trying to live their lives. They just want to go about their lives. They want to put this behind them. They're all pretty much being good citizens now. And here they are being dragged back into their past. So if he was so high, I don't know, maybe I understand why.
How is a jury supposed to count on how is a jury supposed to rely on that testimony to make a decision about somebody's guilt or innocence? I mean, lives are, at stake, people's freedom. And this is the type of witness that's the star witness that this jury is supposed to rely on? I mean, obviously that's maybe a rhetorical question, but the real question that I'd like to see if you can answer is, why didn't the judge throw that guy in jail for contempt? Because if I showed up drunk or high or whatever, you know, they would throw me in jail.
I hope not.
Well,
I'd have more.
Well, I've seen it happen. I mean,
as
I've
the-
had
as
more than
the-
one.
I think if I were to,
go to jail for that.
I think if I were to opine on that, the judge would give one of his comments that he'll occasionally give from the bench, which is, "Do you want to wear these robes, Mr. Weinstein?" And I do not want to wear those robes, not in this trial. So I don't know what the judge was thinking, why he did or didn't do what he did. Again, I think overall he's doing the best he can with a very difficult situation.
I just don't know how you continue with that witness's testimony. I mean, I don't understand. If you have a witness that's inebriated or high or just, you know, I mean, I've had, let's just say, a client that's charged with, you know, just any given, let's just say driving on DUI or something, right? And they show up in court and maybe a prosecutor is nearby and they get a whiff of them and they've been out drinking the night before. They're going to bring somebody over and put a breathalyzer in that client's mouth. And if it's positive, even if it's low, but if it's a positive result, they're going to ask the judge to throw the person in jail for coming to court with alcohol in their system. So I see this where a guy says he's so high that he can't stay awake and nothing happens. And I'm like, what in the world is going on down there in this crazy court, Kangaroo court?
Well, res ipsa, you know, the thing speaks for itself. The jury will weigh his testimony how they believe it should be weighed. Right, Rachel?
Exactly. Well. Exactly. I mean, I think that's an excuse. I mean, the fact that he's high, I think the issue is that the state has people that, you know, in addition to not wanting to testify now, that a lot of the stuff that they're asked to testify about happened not like 10 years ago.
Oh, you know? even longer. A lot of this stuff is 2013. We've been hearing a lot of 2013 testimony.
I became a lawyer
the past few years.
So, like, I mean,
yeah.
All right.
You know,
well, Doug, thank you.
All right.
Thank you so much for coming in here. I know you've got to go. I kept you longer than I told you I would. But anyway, be safe, my friend. And I hope you'll come back sometime. We got a lot that we could talk about, but I hope you'd be willing to come back sometime.
Talk to me when this is all over. I'll have a lot more to say.
All right, brother. Take care.
Okay. See you guys.
Bye.
Oops. Sorry. I removed myself. Let's see. There we go. All right. Now I got it right. How do we get switched up, Rachel? I'm usually on the other side.
Switch me back.
I don't know. Let's see. There we go. All right. I'm still learning, folks. Bear with me. All right. And I've told you all I'm not very tech savvy, but while we're at a sort of pausing spot, let me just take a minute to mention we have, it's like almost 900 people in here right now, which is amazing. Thank you all for spending some of your Saturday afternoon with us here inside the law. Take a minute to hit the like button if you don't mind, because that really, really helps with the algorithm. It helps the show. And if you really want to help the show, and by the way, thank you all for the super chats. If you really want to help the show and you like the content, go to the links that are provided in the show description and elsewhere on the page, where are additional places where you can support the show, because it all goes to at this point improvement. And I'm trying to grow the channel. We're trying to bring you better and additional content, better quality stuff. And I really appreciate. I mean, we just went over the other day, I think it was yesterday or the day before, over 25,000 subscriptions, which is just tremendous. And I'm so honored and flattered even. We're pushing almost 26,000 now. Last time I checked, maybe 25 and a half. The next goal, the next target I want to reach is 30,000. So please, if you haven't subscribed, do so. Tell your friends, tell your neighbors, tell your children, your children's children, your aunts, your uncles, your mail carrier, and anybody you can drag off the street to come subscribe to Inside the Law. All right. With that, thank you. And thank you all, by the way, for the super chats that are in here. They are always very much appreciated. Some of the questions that have been, by the way, chat boss Megan is doing a great job. And I want to see if I can get her to come in and say hello real quick. She's looking at me and she's not giving me the finger. So let's go ahead and see if we can add her. Hello, chat boss Megan. I just want everybody to see who they were dealing with in the chat room. She's doing a very, very good job. How's it going, Megan? Well, not hearing her audio. Maybe that'll come in. But in any event,
I'm in.
Megan, oh, now you're in. How's it going down there?
Hey guys. It's good. I'm having technical issues. I moved my computer and I think I knocked the internet cord or something. So I don't know what's going on, but hope everybody's having a great weekend. And this YSL trial, I don't know.
All right. Well, I'll let you get back to it. I just want to say hi real quick. She's done a very good job of picking out some questions. And one of the ones that she marked was KMD 2210. Doesn't the jury have rights? Also, how can they be required to give up years of their lives? And that's an excellent question. Others have asked the same question about this case. I've asked a question about this case. They get $25 a day after all. Surely they can live off of that. But look, if you're a small business owner, or if you've got kids that have, baseball, football, track, gymnastics, swimming, basketball, whatever your kids are doing, you're going to miss all that. And your business is going to get shut down if you get stuck on this jury. And if you're an employee of another company, and let's just say you're a valuable part of your company it's not easily replaced, maybe, then your employer is going to suffer if they have to do without you and your job for that, and they got to pay you while you're there. So it's a tremendous burden. It's a tremendous burden, almost an unconscionable burden. And I like to what Doug said, I blame Fani Willis because it's her. She is the one who decided to make this case so damn big. She could have chopped it up into smaller bite-sized pieces and have it all over with by now. The same for the Trump RICO case, by the way. She could have made this much smaller, done individual indictments of individual people, but no, she had to do it this way. And she had to do it in a way that inconvenient, not only the lawyers, think about the staff that works in the courthouse, the deputies that are working security, the court reporters are having to take down all this stuff every minute of it, and all the other things that have to go along with it with a criminal trial. It's just taxing on these people. But the ones I think that get taxed the most are the jurors, because they literally have to put their lives on hold. At least you can say for the lawyers that they chose this profession and they, chose to represent, for the most part, they chose to represent these individuals. There's some public defenders in there, but they're on salary. They got to be there every day anyway in Fulton County at the courthouse. So they're there doing their job, and it's the lawyers. Some of them are like small solo practitioners that don't have any partners. They can't take on new cases, and if you can't take on new cases, you go out of business as a lawyer. That's just the way it is. So this is a very burdensome thing for everyone involved. Rachel, you want to comment on that?
Well, the jurors, they don't. What would be hardest for me about, in addition to the financial burden that it places on an individual, it's the fact that you're not allowed to talk to each other about what you're hearing. And you're being told that you can't go home and talk about it with anyone. And that's not for a week. That's not for 2 weeks. That's for, years at this point. And I think that is absolutely unreasonable. And as a result, I think that people are going to talk. And I think that it's going to, if we ever get to a jury deliberation, it's going to affect what information they're coming to the table with. I also think that the jurors at this point, when you watch Adrienne Love over and over again, take her grand old time asking questions that are, any juror, I would like to believe that when she's asking the gang schmexpert about her growing up in Chicago and what her parents said about gangs, I'm hoping that the jurors are sort of rolling their eyes because they too know that it's kind of irrelevant that she's wasting their time. I think that that's going to hopefully affect the jurors in their decisions about whether they've met their burden. They're taking them places to stay on the path. Someone needs to herd the state on the path. And I know Doug didn't want to say it. The judge could be a lot more. I love that. Thanks, Edwin. Thanks. That distracted me. I love compliments. There's no faster way to somebody's heart, including mine, other than a compliment. So thank you, Edwin. No, but the judge could easily just be like, you know what, we're not going to talk about that. But he's allowing the state to get into the most irrelevant aspects of like Atlanta Police Department zoning, like what zone 3 versus zone 4. Really, nobody cares. Like it's really irrelevant. And it's going to be, the state is going to be penalized by the jury, in my opinion.
Are you saying she's over trying her case?
That's what she does. That's what she does. She try her case and confuse the issues.
Keep it simple, stupid. You know,
perfect. Yeah.
I'm gonna. There's some people that came in late, and I've seen more than one comment on this. I'm gonna show what I'm gonna call the contempt video because she should have been thrown in jail. I'm gonna show that again in a minute, and you'll hear the judge say something about prior preparation prevents poor performance. I always heard it prior preparation prevents piss poor performance, but he left out one of those P's. So let's show that real quick, just for those who
get me worked up again. Okay.
Yeah. That's what we're here for. We want to show you everything that's going on here. So this is what should have gotten Miss Love thrown in jail.
Okay. So I'm going to ask the state their issue on this. Are you cutting this out? Did you have discussions with Mr. Sharp, madam?
We did have discussions.
When?
Well, this morning.
That's too late. The evidence is excluded. The evidence is excluded. I'm going to exclude because I told you that this was going to happen. No. We're excluding that, and I'm going to exclude the PowerPoint that you all submitted. Well, you're not going to wholesale introduce it.
We had no intention. Your Honor,
all right.
let's be real clear. We did not intend to introduce this PowerPoint today. I personally reached out via telephone and called at least 2 members of the defense team and asked them to call me back. And I would like
But you all should not be identifying this stuff the moment of trial while the jury's sitting in a box. This is the last. I am not going to tolerate this any further. If you don't get together with your colleagues and flag issues and resolve them promptly, and if I have to take them up, remember, I can exclude them. We'll work the weekends, or we'll do a combination of both. So this time, I'm going to exclude those 2 sections.
Your Honor, Mr. Atkins, he confronted this witness with those sections. I last week let them know that we were introducing that.
If the exhibit's not ready and you haven't made, no, well, Mr. Sharp's got objections to it.
But Judge, Mr. Sharp can get in and have our evidence excluded every day that he makes an objection at midnight, and then comes in and says.
Well, then you all should have gotten your stuff together before then. Some of our juries, please. Some of our juries. Have a seat, madam. Have a seat. You better exclude that, and next time, make sure you're prepared. Make sure you're prepared next time. I'm not going to do this anymore. I'm just not. We are starting right now. It's 1:20. So
we have talked to them. We have said we don't agree.
Then file a motion and get it before me, and we'll take it up. Both of you all have equally responsibility to do that. Oh, it's going to be inadmissible right now.
I'm saying, Judge, you said to file a motion. There's nothing.
I'm not gonna have any more discussion about this, madam. I'm not. I don't. Well, you know what?
And I attempted to try to talk to them earlier this week.
Well, then that's why we have to.
The court punishes the state because the defense.
I'm not punishing anybody, but but prior preparation prevents poor performance.
Be prepared, Judge. That's why I sent them what I sent them last week, a whole week and a half ago, 2 weeks.
I'm not. Well.
And I have said I would like to discuss.
Our jury's coming in, madam. Our jury's coming in. Have a seat.
And whereupon the jury returned. Listen, and that when you read transcripts of trials, that's what the court reporter puts in there. So, look, I mean, there's so much that we can say about the what we just saw, which is just reprehensible conduct. I mean, I've never seen anything like it, and I would imagine that if I see something like that again, somebody's going to wind up in jail, and it's not going to be the judge. I don't understand how she's not in jail. But that's just me. I'm not the judge. I mean, but I just don't understand. I mean, we have rules of professional conduct that apply to lawyers, but also that apply to judges. The judge also is partly to blame for letting his courtroom get out of control. He's lost control of that place.
Well, Doug,
it's become a disaster. It's a dumpster fire, kangaroo court, call it what you want, but he's lost control of it.
Completely. No. So what Doug said, I thought was really insightful about the fact that when when the judge will say, I'm gonna exclude this. You didn't give it to the defense on time. The defense has objections. Now we're here. We have the witness here. And now you want to start going back and forth about whether it's admissible. You didn't give it to them in a timely manner such that they could file a motion in limine to exclude it. And then when the judge will say, well, I'm excluding it, then he keeps going back and forth with her. And what Doug was saying is that then she'll do that. They'll go back and forth, and then he'll walk back his ruling. So over time, the state becomes conditioned to know that when he denies their motions or, grants a defense motion that hurts their case, she believes that if she just keeps arguing louder and if she gets meaner and acts, I guess, more like a bigger bully than she already is, the judge will relent and let her do what she wanted to do in the first place. She has never been punished.
Guys, I think it's fair to say that Rachel may not be a fan of Miss Love. What do you think?
No, I can't be on any. No, I would have to ask, like in a case where she is assigned as a prosecutor at this point.
Oil and vinegar.
It cannot happen. She needs to recuse herself. I can't be in a room with her that long because I truly, she works me up. I feel bad for anybody that has to sit in there, for Doug, for anyone. She is monstrous, and there's no kindness coming from her soul. It's just hatred for everything. And, she's smart enough and she's seasoned enough to know how to kind of get away with it, telling the judge that, that the rules of evidence favors admission. Okay. Well, it doesn't favor wasting everyone's time on things that don't matter.
Well, the judge is complaining. I mean, how many times have we heard him threaten to work weekends and all this stuff? And he keeps threatening that. But if he would get control of his courtroom, he could run it more efficiently. And, so some of this, I would lay the blame at his feet. It's not just the lawyers. They're being advocates. And I've seen him threaten lawyers with contempt just for being an advocate, which is what they're supposed to be doing. If they do something and it's not maybe the way he would do it, if he were an advocate, he starts yelling at him. I mean, I saw him. We talked about this on one of our other shows about this trial, where he threatened a defense lawyer. Apparently, he appeared to be threatening a defense lawyer for merely making an objection, filing a motion in limine, which, by the way, the rules say you don't have to file a motion in limine. It's discretionary. It's however you want to do it. And the judge doesn't get to decide how I strategically try my case. That's a me call. That's the lawyer's decision, not the judge. And if the judge doesn't like the way that I'm doing it, that's just tough shit. It's not the judge's job to tell me how to do my job. But in this case, he was getting frustrated because he did not agree with the way the lawyer was handling his business. And he starts yelling and screaming. And I think it's ridiculous.
One more other thing is part of me wondered if the way that he yelled at Adrian when he had already said that he was calling Miss Love, I'm not calling her Miss Love, Adrian, whenever the judge was calling in the jurors, the fact that the judge had previously in front of the jury kind of called Brian Steele unprepared and called, I believe, Max Shard unprepared, or made some kind of statement like that. I almost believed that the judge was saying it loud enough so he could feel like he did it to both sides in front of the jury. And it didn't seem like he was only yelling at the defense for being unprepared. It felt weird. He was baiting her so he could have that conversation loudly, knowing that the jurors are on the other side of the room. There's a wall in between them, but it's not like they're down the hall and around the corner. I mean, they're right there. So they heard that. They had to have heard Adrian.
So the chat room is getting busy. We've got almost 1,000 people in here, and
welcome.
Got her hand.
Welcome to the party.
So we're gonna switch to another topic here in a minute. But before we do, Susan asked this question about this sign behind me. It's not the actual sign from Folsom Prison, but it's one of my favorite knickknacks, and I've had it around my house for a while, and I really didn't know where to put it. But finally, when I was setting up this space to do this streaming, I'm like, aha, That's like the perfect thing. It's just one of my favorite. Y'all may not like it. I don't know, but tell me in the chat room if you like it or if you don't like it. And by the way, in the chats, if we say things that you disagree with, tell us. If you see things another way, tell us. If you like what we're saying, tell us. Or like somebody thought Rachel was hot, tell her that too. I don't get anybody telling me that, by the way, Rachel. I'm just letting you know. But look, however, whatever you want to say, put it in the chat. Just please be respectful. But we do want to hear what you have to say. I set these up so that usually, unless there's some editing that's unexpected on the back end, when people watch the replay, they can watch the live chat replay as well. And I try to keep an eye on what's going on in the chat as we go through it, but I miss a lot. So sometimes I'll go back and look at what was said in the chat, because it helps me figure out what's working, what's not working, what people like, what they don't like, and what I might be able to do better next time. And by the way, if you like the content, feel free to check out the show notes here. There's some links in there, how you can support the show. We're still trying to grow. And by the way, someone, Anonymous Jeff, has gifted 5 Inside the Law memberships, and that's also very appreciated. It's another way that we grow the channel, and we've got almost 200 members in the membership right now. So
you guys have me laughing and blushing in the comments. Look at it. Oh my goodness.
All right.
Okay.
So
go Coco.
All right. So here we go. We've got the next thing that we're going to move into. We are going to talk, as you know, I did a show yesterday, a live stream, where I talked about the jury that was picked in the Donald Trump trial that's currently underway in Manhattan. And of course, this is a case where the former president of the United States is facing criminal charges in a criminal trial brought by a political adversary named Alvin Bragg, who's the district attorney. By the way, I think you can go to New York and you can commit an armed robbery, you can commit all kinds of violent crime, and you barely get prosecuted. But Donald Trump engages in what is accused of being a bookkeeping error that the statute of limitations should have run on years ago. The district attorney bootstraps an unspecified felony and says he did so to try to commit some other crime, and he doesn't say what the crime is, and somehow that makes it a felony with a little bit longer statute of limitations so that he can avoid that legal impediment to prosecuting Donald Trump. Again, this is called fraud, but there's no victim. All kinds of things wrong with this indictment, in my opinion, but I did an entire show on that. Go back and check it out on this channel. I went through the indictment count by count, and we talked about that. And yesterday I went through and talked about the people that were selected on the jury, what we know about them, and how if it were my case, how I might have viewed that potential juror making it onto the panel. But here we are. We've got 12 jurors. And we've got 6 alternates. And on Monday, we are told opening arguments will begin. Now, if you contrast that to like this young thug, the YSL trial that took him a year to pick a jury, but of course you had a lot of defendants and a lot more lawyers. But, it would seem to me that when you have a case like this, where you have such strong feelings, I mean, everybody's got strong feelings about Trump, whether you like him, whether you hate him. There's strong feelings everywhere. And so it just blows my mind how you can blow through this and get a jury in it's actually 4 days. They took Wednesday off. So they whittled down 500 people out of the borough of Manhattan, which, by the way, Trump only got 12% of the vote in 2020. And now I think a lot of the conservatives, the people that might have been more open-minded to Trump, have fled. They all went to Florida and elsewhere to escape New York. So I think the demographics there are even less favorable for him now. But Judge Merchan says that he thinks he's got, a fair and impartial jury. We've talked about that. We've talked about that before on this show, where, it's the judge's job to make sure the Sixth Amendment is the right to a fair jury is afforded to the defendant. It's the judge's job. And now people are even questioning whether the judge himself is fair and impartial. You got a right to an impartial judge. And so the lawyers asked Judge Mershon to recuse himself, and he said no. He said, I'm not going to do it. That's a thing that should have gone to a different judge, because Judge Mershon can't grade. It's like grading your own paper when you're in school. At least when I was in grade school, sometimes they would say, okay, hand your paper to your neighbor. So at least you're not grading your own, right? That's kind of the same thing. I want to show you another quick video. I did an interview the other day, and I want to share just a couple of minutes with you. I'm not going to share the whole thing, and then we're going to get started on what to expect with opening statements.
Phil Holloway, former assistant district attorney, retired U.S. Navy, former police officer, and legal advisor to Georgia Sheriff's Department. Look, we don't want to get into the individuals on this case that they're trying to seat the juries. They're having a hard enough time as it is without too many details out there. This was going to be hard anyway. This is New York City. This is where Trump made his name.
Harris, great to be with you as always. You know, the Sixth Amendment guarantees all criminal defendants a lot of rights, but the one that we're focusing on here is the right to an impartial jury. And of course, due process also says you have the right as a criminal defendant to an impartial judge. Those are the themes that we're seeing coming out of the courtroom. There are major questions about whether the lawyers for Donald Trump can, in fact, find an impartial jury. And that is ultimately the judge's job. And the judge, of course, himself has to be impartial and unbiased. And there have been claims, and some of them, I think, have at least some merit, that Judge Mershon himself might be somewhat biased against Donald Trump. So what we're seeing the setup for, I'm afraid, is a trial that the result of which, irrespective of what that result is, the result might not be something that future historians will look back on and say this trial achieved justice. His lawyers, Harris, have to go through all of these jurors and ask leading questions and questions that are probative of maybe their past social media history to determine if, in fact, they're telling the truth about whether they can be fair and impartial, because it's one thing to say I can be impartial and quite another to actually be impartial. So it's quite the job that not only the lawyers have in this case, but ultimately the judge has to be impartial. He has to do his job and make sure that the ultimate jury is fair.
Who's making sure that Judge Mershon is being fair? Whose job is that?
Well, that's a great question. The lawyers who are representing the former president are raising some of these issues. They asked the man to recuse himself. In my opinion, what should have happened, Harris, that motion should have gone to a separate judge to make that determination, because basically the judge has said, no, I am deciding that I myself can be fair and impartial. And that fact alone says that's a conflict of interest. He needs to have another judge answer that question. Because, again, we want to make sure that the result of this case is one that we can be confident in was the right result, no matter what it is.
All right. As things happen in the courtroom today, and they always do, we'll bring you that news contemporaneously, whatever it is, and also show you the president if you should come out and talk with microphones. You know, Phil, I did want to say this with regard to the investigation. One more just thing about the gag order. Where are we in that, and what in the world is he allowed to and not allowed to talk about? But other people can talk.
The problem with the gag order, Harris, is the First Amendment. You know, you have a right to speak your mind. The gag orders traditionally apply to lawyers and, in fact, prosecutors that you don't want trying their case on the courthouse steps. But the problem is, in this particular case, Donald Trump is expected, apparently by Judge Mershon, to sit back and listen while Michael Cohen and others say all sorts of things about him that are negative, that may or may not even be true. And he is expected by this judge to keep his mouth shut and remain silent. And that's just not right. It's not what the First Amendment is all about, and I think the gag order goes too far.
All
right. So I think the gag order goes too far, as you heard me say to Harris the other day. Look, whether you like Trump or you hate Trump or you're somewhere in the middle, there's just so much that we can learn about the law and about the process in the context of the Trump case, the Trump cases, the one here, and of course the Young Thug case. And, you know, we're going to get into the Koberger thing as well, because, you know, we got a new alibi. So we're going to talk about cases that are, it's not just Trump and Fani Willis and Young Thug all the time. We're going to be getting into some other things, but these are the things that are in the news right now. And there's so much teachable that we can talk about. The gag order, for example, those things aren't really supposed to gag defendants. They're supposed to keep lawyers from trying their case in public, like Fani Willis did in the church here in Atlanta. And so defendants have a First Amendment right. The media has First Amendment rights. And so I don't like gag orders. I've never been a fan. If Barack Obama was the defendant, I wouldn't want him to have a gag order either. But we just happen to have Trump on trial. And so we're going to talk about gag orders in the context of the Trump case. We're going to talk about jury selection in the context of the Trump case. And we're going to talk about opening statements now in the context of the Trump case, because that's what comes next. After the indictment, you've got arraignment, you have pretrial motions, you fast forward, you get to a trial, you have jury selection, which quite frankly, it should have taken weeks, but nevertheless, the judge barreled through it at lightning speed. And he says he's got 12 jurors plus another 6 alternates who the judge believes are unbiased. I have my concerns about that, but nevertheless, we've got to get into opening statements because that's what's happening Monday. Rachel, you know something about opening statements because they occur in every single trial. What do you do in an opening statement when you have a case?
My goal is to tell the story from our perspective. It's what I expect the evidence to show and not show, and what the burden's going to be. And you're not supposed to do, much argument. So I just try to stick to, the story as if I was telling it to a friend who didn't know about it. Because you're really welcoming them into a really difficult process, and you've spent a lot of time, deep diving into it. But you have to remember, this is the first time, well, not really the first time, but it's the first time that these jurors are hearing about the facts of the case. Usually, in this case, I don't know how the jurors would not have seen or considered media that they had previously heard. My overarching thought, though, is that the state's going to get up there and act like Donald Trump did some horrible thing by doing what he's accused of doing.
Bookkeeping violations.
I just don't care.
Who got hurt?
I don't really care, but to be honest with you, bookkeeping violations. We talked about Fulton County last week. They don't even keep a book. Plus there's the attorney-client privilege issues that I don't like this with the.
Yeah, I wonder if Fani Willis has ever booked anything improperly with her budget. But speaking of, before we get too far into opening statements, you mentioned the jurors, and I happen to have gotten my hands, a secret source handed me this juror questionnaire, and I want to take just a minute to we're not going to go through all of it, but these are the types of questions that they got into. So without telling us your address, where do you live? Upper East Side. How long have you lived there? Are you a native? What do you do for a living? How long have you been doing that? Are you retired? Education, employment. Are you married? You got kids? If you are married or living with another adult, what does that person do for a living? If you have adult children, what do they do? What do you do in your spare time? What are your hobbies? Do you participate in any advocacy groups or any clubs? You ever been on a jury before, grand jury or otherwise? Which of the following print publications? Where do you get your news, basically? And they give a laundry list of places. Do you listen to or watch podcasts? Do you watch Inside the Law on YouTube, for example? Maybe they do. Do you listen to talk radio? Which ones? Do you have any relatives that work in law enforcement or with the prosecutor? Any close friends or cops? Those sort of things. Any specialized training in criminal or civil law? Any relatives in law? You've been accused or convicted of committing a crime? Anybody that have a pending criminal case? You have any political, moral, intellectual, or religious beliefs that might prevent you from following the court's instructions? And by that, some people have a moral or religious objection. I hear people sometimes say, I can't sit in judgment of another person because my faith tells me that is a sin. So I have seen that before, and maybe you have too, Rachel, but sometimes people say they just can't sit in judgment because of religious beliefs. And they go on asking about health conditions, things that might interfere with their ability to serve. Do you practice a religion that would prevent you from sitting as a juror for any particular weekday or weeknight? And these are the types of probing questions. And this is one. Have you ever considered yourself a supporter or belong to the QAnon movement, the Proud Boys, the Oath Keepers, Three Percenters, Boogaloo Boys, or Antifa? And I would love to see how some of the people who didn't make it onto the jury answered question number 30. But anyway, do you even have any strong opinions about whether a former president could be charged in a state court? Strong opinions about Mr. Trump, how he's been treated? Have you read any of his books? Have you read any books by Michael Cohen? And it goes on to ask, have you read any books by Donald Trump? The U.S. Constitution provides the defendant has no burden to introduce any evidence or to testify. If he chooses not to testify or to introduce any, can you give us your assurance that you will not hold that against him? Is there anything else that would be a bias or something else that would prevent you from being fair and impartial? So that's the questionnaire, and that's what the jurors went through pre-trial. And so the lawyers had a lot of this information before these jurors walked in the room, Rachel. And I'm thinking that might be at least part of why they were able to get through this so quickly. But look, I've got a lot more questions that I would want to ask. Wouldn't you want to ask a little bit more than that?
I guess it's surprising that they were able to select a jury in 4 days when we know that there are so many people that have strong opinions about Donald Trump. One of my friends reached out to me and asked me, like, can you get in trouble for not telling the truth? In jury selection, you take an oath to tell the truth. There are some things that there's no proof of. So like who you voted for, like they can't really check that. However, it seems as though Donald Trump's team, and as they should, if they have the resources, to be able to have a jury consultant that's actually looking at these potential jurors and kind of fact checking what they're saying. So someone says, no, I'm not somebody who has a strong opinion, but then they're writing, memes about Donald Trump in a garbage can on fire or something. They're like, okay, well, like that was a few years ago. If they can explain that they had that opinion and changed it and they're still willing to be fair and impartial, most judges in Georgia would just say that person stays on. But I just can't imagine how this went down in 4 days, but I guess it did. But maybe they all had to submit the questionnaire beforehand and were just doing follow-up questions. Unclear.
Well, normally they'll give you an opportunity to ask some follow-up questions. Surely they did, but I mean, we don't have cameras in the courtroom, so we really don't know. We got to take the word of the journalists that are in there, and so some of the information that comes out might be wrong. I mean, journalists are most of the time really good, but they don't always know what they're hearing when they see this stuff.
The judge instructed them to not report on anything that they see in the courtroom. Towards the end of the week, because one of the jurors she was a nurse, and they had identified publicly where she worked as a nurse. And so people were able to figure out that she's on the jury. But this in my stream yesterday, and again, please feel free to go back and check that out, because we talked a lot about jury selection, went through it and talked about the actual jurors that made it on. If you tell your boss, hey, I can't tell you what I'm doing, but you're going to have to find somebody to take over my shift for the next 6 weeks, because I'm going to be downtown Manhattan, but I can't tell you why. Mm-hmm. Your boss is going to know. Your boss is going to know where you are and what you can't be on the Trump trial as a juror without people figuring it out. And that's why this really feels like, again, I'm not political. You and I have kind of discussed politics privately. I'm really not in it for any of that stuff either. This feels like a political prosecution. It does.
It is.
I mean, I'm wondering how many people have paid people to shut up. I mean, a lot of people.
I mean, it's non-disclosure. Fani Willis has them in her office. It's common. It's a contract that's commonly used by people that, if they're non-disclosure agreements. Rich people, powerful people, high-profile people use them all the time. And maybe it's because you don't want somebody to talk about something that may make you look bad professionally, or may make you look bad in the media. But that's okay. It's legal to do that. Okay. There's nothing illegal about it. And by the way, Michael Cohen So apparently the way this is supposed to have gone down, Michael Cohen told Trump to do it this way. Trump did it this way. And now Michael Cohen, as I understand it, wants to come to court and testify that Donald Trump committed a crime for doing what he, as his lawyer, told him to do, and therefore should be in prison or something like that. But you said it feels like a political prosecution. I think it is a political prosecution. And I would say the same thing if the shoe were on the other foot and this were a Barack Obama, a Bill Clinton, a Joe Biden. I would say the same thing if any of those individuals had their political opponents who were the elected prosecutors, doing this kind of thing over a bookkeeping problem from 2017, which was a misdemeanor, by the way, and where there's no victims. And I just don't understand how we got to this place in America, but yet here we are. Anyway, I don't want to get too political about this either, but what I can tell you is that to me, this is not about Donald Trump, and neither is the case with Fani Willis. This is about fundamental fairness. This is about a fair justice system. This is about due process. It's about the Constitution working the way it's supposed to work. And if they can do this to a former president of the United States, whether it's Donald Trump, Barack Obama, anybody else, they can do it to the least of us, and our rights go away as well. Anyway, that's my soapbox. Do you have one?
Yeah, I like to for Trump's fan base or his political base. I feel like this political prosecution is actually just sparking more interest and fire and support for Donald Trump, because it really does feel like we're talking. Like, I just want to be clear. Like, we're talking about him through his lawyer. They're accusing Donald Trump of using Michael Cohen to pay off Stormy Daniels, who was a woman that he had an affair with before he was running, so that it didn't get out.
Yeah, well, he denies it. At one point, she did, and I think he sued her for defamation for saying it happened, and I think
extortion.
He won.
It
smells like extortion. It really does. Yeah.
So the whole thing is a little bit like confusing to me, how it's now center stage, and that these liberal. I don't like virtue signaling.
Well, you got so much other crime going on in Manhattan, but this is what we're spending our resources on. Same thing here in Atlanta, Fulton County. We're spending our resources, in my opinion, in a terribly misplaced way. But let's get back on track. Let's talk about opening statements. Okay. You were saying that the opening statement, you said, is a roadmap. And that's what I like to say, is that I want to tell the jury what I think the evidence is going to show, so that when they hear that evidence and when they see that evidence, they're going to go, aha, Holloway's right. He wasn't lying to me. He was telling me the truth. He said this was going to be the evidence, and here it is. And so that, you get an opportunity to, build a rapport with the jury, and also to develop sort of a relationship, if you will, so that they can trust you. So by the time closing arguments come around, if the trial has gone the way that you told them it was going to go, and they got this from this witness and this from the other witness, you can say, remember at the beginning of this case, I told you that all these things were going to happen, and here they are. This is how it happened. So that it gives you some credibility. So when it comes time to do your closing argument, which, by the way, you're allowed to argue more persuasively, opening statements are merely supposed to be a thumbnail overview of what the case is supposed to be about. But you're setting up the trial. You're telling the jury what to expect for the journey ahead.
And so for Trump's lawyer, I think that's going to be more interesting and up in the air as to how they're going to respond in an opening statement. You can always reserve your opening. So as a defense attorney, I know Bruce Harvey did it in the YSL trial. You don't have to give an opening when the state gives their opening. You can wait until the judge, I guess the state's case in chief is closed, and then you could do your opening then before you present witnesses if you're going to. So that is a possibility. I thought Donald Trump said he's going to testify, so I don't know what's going to happen.
Well, we don't know. It's, of course he's going to say that now, and he doesn't, and that's a decision that is made after the state rests, because, you know, it might be that you think that you've got the case won. And so you can unwin it for yourself if you have your client take the stand and they don't do a good job. And I've seen that's happened to me in more than one case. But normally it's better to not have the client testify. That's sort of my default setting. But there are cases where it might make sense. And I think in every case, the jury usually wants to hear from the defendant, especially if it's a whodunit. This is not really a whodunit necessarily. And I don't know if the jury is going to feel the desire that they want to hear from the defendant. But if they don't, this is why we're asking questions up front about if they don't testify, can you not hold it against them? So it's a decision that the defendants will make after consulting with their attorneys. But in this case, I'm not so sure Donald Trump isn't going to just do what he wants to do, irrespective of what his attorneys might advise him to do.
Sounds like Fani. I mean, again, the parallels. No, the parallels are striking, and the problem is that nobody's self-aware. You know, I wish everyone could just be like, "Yeah, I had an affair. Whoops, I paid her because she was threatening to go." Who cares? I mean, we're all past that. I don't. That can't be what the Manhattan DA's office is spending their time on. I mean, are there not open homicides? Like, they're not thousands of people on Rikers Island waiting?
Yeah, I mean, this is where I think there's very little daylight between you and I on this issue. I think that prosecutors need to, and judges as well, need to spend the limited and precious resources of courts wisely. We've got more than enough crime to go around. We've got a ginormous backlog from COVID, but we had a backlog here in Atlanta before that. There's a backlog everywhere. You know, and now they want to take this case that should have had a statute of limitations expire, somehow revive it through some legal mental gymnastics that don't make any legal sense, and try to call it a felony. And now we're in 2024, and we're going to litigate bookkeeping issues that occurred in 2017. And it blows my mind how much money and resources the city of New York is giving out debit cards to the illegal immigrants that are up there that they need to give money to. Then that's costing the city gazillions of dollars. This trial is costing gazillions of dollars. They've got to be running out of money. And so they've got to be able to figure out what are they going to do to devote resources to the real criminal problem on the streets of Manhattan.
Yeah, I mean, my understanding is there've been tons of crimes happening on the subways. There's people setting themselves on fire outside the trial.
Oh my God, that was crazy.
I mean, there's lots of stuff going on, and we're talking about, I mean, agreements between adults, and then their attorneys, telling on them, even though they're the ones that advised them to do it and actually did it. Ugh, it's gross. And that's why I haven't really paid much attention to the case, because I'm just kind of like annoyed that it's even happening, honestly.
Yeah, well, a lot of people are annoyed that it's happening, but let's talk about one other little issue that we're going to look, because opening statements will last maybe a day, or I don't know. It depends on how much time the judges give them. We may start, if it's Monday morning, we may start seeing evidence Monday afternoon. One of the star witnesses, Michael Cohen, the former lawyer who has pleaded guilty to felony crimes in federal court, will be one of the star witnesses in the case. So tell us, Rachel, please, how it works when a witness takes the stand who is a convicted felon. And let me preface that by telling our viewers this. When you are a witness in a case and your ass sits down in the witness chair and you take the oath, immediately upon taking the oath, your credibility, your character for truthfulness is an issue in the case. So what do you do when the witness is a convicted felon, Rachel?
So as a criminal defense attorney, I actually probably have a lot more empathy and understanding as to how somebody could be a convicted felon. So I'm thinking about all the ways that it's going to help me. But understandably, especially when it's a crime of moral turpitude, meaning it's a crime that really affects your character for truthfulness. If you've lied before, if you've, passed bad checks, identity fraud, lied, basically. I mean, those are crimes that are obviously very relevant to your credibility. I don't know I imagine that the state is going to handle that head on, because that's what you do. If you're going to say you've been convicted of things, you've taken responsibility. whatever, you've paid your price to society and now you're here.
Yeah. So it's called, you're right. It's a strategy called taking the sting out. So the procedure would work like this. If a witness is a convicted felon and the felony is not super old, and so it's still relevant, the jury ultimately will be given instructions at the end of the case. And one of the instructions that they will get will be that if a witness is a convicted felon, then the jury would be entitled to disregard the entirety of their testimony, regardless of what the felony is, or if it's a misdemeanor involving, moral turpitude. But here we're dealing with felonies involving, I think, moral turpitude. So it's called impeachment. You basically discredit the witness with the prior conviction by pointing it out. So you literally will have a copy of it, a certified copy. You say, "Isn't this you?" And you have a whole packet that's got the official court document, so you can wave it around in front of the jury, and use that as one of the reasons to tell the jury that they should disbelieve this witness's testimony. In the case of Cohen, there's lots of things to point out, including prior inconsistent statements and things that would show a very real bias against the defendant, which is a motive to fabricate testimony. That's the way the argument would work.
He was his lawyer. I don't understand. Like, I'm not going to do this with a client. I mean, I wouldn't agree if it's in fact true. As his attorney, I would ethically have to say, no, we're not going to do that. That's because he's looking to me for counsel as to what's appropriate and what's not appropriate. The fact that Michael Cohen authorized this whole thing and then got paid out of it, and then now he wants to say that Donald's the problem. It's like, you should have said no. Where was you? I don't understand.
Yeah. Well, I mean, it's like I said, there's nothing wrong with a non-disclosure agreement. The payments were supposedly made from Trump or the Trump organization to Cohen, and they were booked on the books as entering the books as, a payment for legal services. Cohen turned around and paid the money to Daniels allegedly. And so that's why we're, why we're here.
Really?
It's just, you can't make this so ridiculous.
It's too much. It's too much. And there's everybody. I mean, I just want to know if all other public officials, they have to have done similar things. You and I were discussing why we're not going to become judges or DAs. It's because, I don't know, skeletons in my closet are just choices that I make that maybe aren't acceptable to the general public. I mean, everyone's
not anymore. Anything goes.
Well, happy 420, everybody. But everyone's got their, their skeleton in their closet. So I just wish people were more honest about it.
Speaking of everyone, we have 1,060 people in here right now. Thank you all very, very much for being in here, and take a minute to hit that like button, please. And by the way, I said this earlier, but for those of you who may not have been in here earlier, I'm pushing on, I'm knocking the door to 26,000 subscribers, and I want to get to 30,000. That's my goal. So please, if you haven't subscribed, do so. Tell your friends and family. And if anybody that you want to suggest to, help me find some extra subscribers, would you? And also, if you like the content, thank you, by the way, for the super chats. They're very much appreciated. They help me grow the channel. If you like what you're hearing, check out the links on the show page to support Inside the Law. Rachel, we've been going at it an hour and a half, and I've got, I got to take my son to the Braves game. I know it's hard to be me, but that's what I'm getting ready to do. Are you doing anything fun the rest of the day, or do we need to ask?
No, I mean, fun depends on who you are. But yeah, I'm going to have some fun.
All right. Well, we're going to say goodbye to Rachel. Thanks so much for coming in, and we'll talk to you later. And listen, and thank you again, everybody, for being here. I really, really appreciate it. And we're going to be doing this on a more regular basis, is my intention. We've got a lot to talk about with the Trump case, of course, and other things. And we're going to be able to hopefully jump in on a moment's notice if we have breaking news. I've got an alternative place where I can stream from at my office. And before I go, let's say hi one more time to chat boss Megan. Hello, Megan. How are you? Can you hear me now? Did you get everything set up?
I think so. I think that I have a lot of things streaming in my house right now, so that might be the issue, but who knows?
Well, a lot of you have dealt with her in the chat room. I've seen you interacting with her, and I just wanted to bring her out and introduce her one more time and say thanks again. And I'll let you go back to where. So I guess you may have a lot of stuff streaming. So I'll go ahead and we'll say goodbye to Megan, and thank you all very much. And we hope that you have a happy and safe rest of your weekend, and we will see you back here next time inside the law.